Okay, my reason for requesting that the court cancel the current parenting time order, and I'm requesting that the court give me sole custody of Bella and reduce Ryan's visitation time to supervised visits only until he gets some sort of help for his multiple violent crimes that he has committed. He presents a danger to Bella, as he was arrested on July 1st for attacking her and I was holding her while he was repeatedly punching me in my head, trying to prevent me from running across the street to call the police. Since then, he has taken no responsibility for his action. He has showed no shame, guilt, or remorse. He has pranced around as though he is the victim, when really Bella and I are the victims. He acts like he should still have the same access to Bella as he did before he was arrested for his assault. Also, I am this I'm a stay-at-home parent to Bella. Ryan is usually out of the house working full-time or more. I quit my job in early 2001 at the request of Ryan, and because we both agreed that it would be best for our family to be a stay-at-home mom. Despite your order that he petitioned the court for, that he needed 50-50 parenting time, when him and I moved back in together, it was a very short period of time before I was established as her primary caregiver as well. If you allow him to keep 50-50 custody, that allows him to avoid accountability, and it also allows him to further perpetuate his control and abuse as me and Bella suffer the negative consequences for his arrest. Her and I are used to being together 100% of the time. It's very rarely that she's in the care of somebody else. Ever since his arrest, all of a sudden he wants to activate his parenting time, taking away from mine and Bella's established emotional, physical, mental bonds. I'm asking the court to assign the guilt and the punishment.
This hearing is already becoming highly emotional. The mother is asking the court to immediately change custody arrangements because she believes her child is in danger. The father's attorney, however, argues that today's hearing isn't about changing custody at all. It's simply about enforcing the existing court order. That legal distinction is about to shape everything that happens next.
The guilt and the punishment to where it belongs on Richard Beck.
Okay. Ms. Sharp, your response.
Thank you, Your Honor. First off, this is an objection to enforcing an order. This is not a ex parte motion regarding trying to modify custody and parenting time. My client has a criminal case that's currently pending, but what's happening is very likely to be dismissed. In the meantime, the mom has gotten a felony parental kidnapping charge against her. The allegations that she doesn't see, or he doesn't see his other children. He sees his other children because now she's out of the picture. There are concerns about her mental stability. And as of now, what's been happening is when he does get his child, they've been doing a third party. His mom has been doing any of the pickup drop-offs, but every single time the mom gets the child out of the car, immediately she says, "Did daddy hurt you? Did daddy touch you?" And it's extremely sad that she's continuing to alienate, given the fact that there is no CPS case whatsoever against my client. So all my client is asking for, and this is what he asked for in the ex parte order, was just to enforce the current parenting time per the order. So again, I don't see, if mom files her own ex parte, that's one thing, but she has yet to do anything like that. But this criminal case against him is actually going to be very likely have a dismissal based off of somebody in my office is handling it, and based off of discussions with the prosecuting attorney. So my client's just asking to, again, enforce his current order, and that is also written in the ex parte order. Thank you.
Thank you. Anything else, Ms. Martinez?
Yes, I understand that this is not an ex parte order. This is my objection to your ex parte order to enforce his parenting time. I was not parentally kidnapping my child. I was parentally protecting my child. Ryan's abuse and his history of domestic violence for me has been testified in your court in a different case where witness introduces testimony and Ryan's history of domestic violence in our home towards me as her reasoning for denying him his parenting time. She did not feel her children were safe with him. There are other violent charges that Ryan has, except for domestic violence charges against me. He has been charged with assaulting a police officer twice. He's been charged with assault. He's been charged with drunken driving. He's been charged with child endangerment. And these are all recorded in the court in which we are in. They have been all, this is not speculation. This is not me bashing him. This is what has been already proven and testified to in court that lays an underground, it lays a pattern of behavior for Mr. Beck, a violent pattern of
So does it
behavior.
for you.
Sir,
No, because
don't talk.
so
Yes.
it establishes a violent pattern of behaviors with Mr. Beck. Him and I were together for 7 years. I could not count how many times he put his hands on me. When I left him after Bella was born, this is when he petitioned the ex parte order because, he thought I had no right to protect my child from him and his violence. And he thought he had every right to Bella. And this order was used as a way to extend his abuse, to extend his power and control. This is not about him spending more time with Bella, because when him and I moved back together after we got sober, it was his idea that I'd be the stay-at-home mom. He established me as her primary caregiver. And
At this
I
point, the judge steps in to narrow the focus of the hearing. Rather than revisiting years of allegations and relationship history, the court is concentrating on a single legal question: should the current parenting order remain in effect? Family court hearings often turn on procedure, meaning even serious allegations usually have to be addressed through the proper legal process before existing orders can be changed.
And I do feel like that I should be his sole primary caregiver, considering his recent
Stop
arrest.
talking, ma'am. I'm not going to go back and relitigate this whole case. We're addressing only the order that ordered the immediate return of the child, and ordered that, again, that you would participate in exchanges at the Emmett Police Department, utilizing a third party, and that could utilize law enforcement to enforce the order. That's the basis. That's what your objection was to.
Okay, I object to that ex parte order. In addition to my objection, I would also like to ask that I do ask Bella, were you safe? Were you okay? Was anybody mean to you? Did anybody hurt you? Did anybody hit you? And I tell her, it is not okay for anybody to hit you. It is not okay for you to hit anybody else. These are questions that are safe and okay for a parent to ask. It shows the corrupt mindset of Mr. Beck and his accomplice, Darcy, because only people who are not safe would have a problem with you asking your child if she was safe.
Okay. Anything else as it pertains to your objection, not the extraneous ancillary things, ma'am?
This is a very complicated situation. It has turned into a felony charge for me. So I would like to object to the third party. Darcy, his mother, does nothing but enable and become herself a physical extension of his abuse, of his crime. She is listed on every single one of his court dockets as being the one who bonded him out to help him escape accountability.
Okay, thank you. Well, what we have is obviously there's a history here, and Ms. Martinez has various objections to the current order, but the objection to the ex parte is simply to enforce the current order that remains in place. She has not filed an appropriate motion to again change or modify those particular orders. All the court was doing is enforcing the current orders. Ma'am, if you have an objection to those or a dispute, you can file an appropriate motion to seek modification, but the objection to the order is not appropriate in this matter. So the court is denying the objection at this time, and let you know that you can file an appropriate motion if you choose to do so. So that will be the.
Are you telling me that you are ordering that I turn my innocent child over to a convicted violent person that has been convicted of violent charges in your own personal court?
Ma'am, I am enforcing the orders that currently exist, If you want to change those orders, you can file a motion to seek modification of the orders, but I'm seeking to only enforce the orders that remain in place at this time. So that is the order of the court. The court will end this matter at 10:47 a.m. You're free to go. Have a good day.
Thank you.
Her danger's in your hands.
What?
Who should prepare the order?
Ms. Sharp, you can prepare that order. Well, she's gone. We should have an order on this because it was, well, no, it isn't.
In the end, the judge denied the objection and ordered that the existing parenting arrangement remain in place, explaining that any request to change custody must be filed through a separate modification process. While both sides strongly disagreed about the facts, the court's decision focused on following the current legal procedure rather than deciding the underlying allegations during this hearing. If you enjoyed this courtroom breakdown, hit that like button, share your thoughts in the comments, and subscribe for more real courtroom drama and legal analysis.